I withdraw the case.
Very good. Mr. Z. Hussain, Learned Counsel for the petitioner, on instruction submits that he be permitted to withdraw the present writ petition. Prayer is not objected to by the Learned Counsel for the respondent. Accordingly, the present writ petition stands dismissed on withdrawal. What happened to the title suit? Title suit is still pending.
My lord, when the title suit is, my lord, is against me, subsequently I filed the appeal. Appeal is in favor of me, my lord. That is
There was any interim order here?
earlier, my lord, status.
Interim order, if passed, if any, stands vacated.
Yes, may I please, your Lordship, I beg to mention for listing for writ petition, Lordship, the matter pertains to, Lordship, electricity connection, Lordship.
Kindly mention before the senior bench.
May I please, my lord, with regard to item number 9, my lord, the matter has become infructuous, my lord. Matter has become infructuous, my lord. So
Why?
So we have not got any interim order, my lord, and the said already been.
Have you paid the money? Your rent?
Regarding that, actually the file is also took back by the client, my lord. So we don't have any instructions.
Who is appearing for this?
AIDC, my lord, whose name is.
Call Mr. B. Gugul. Let the matter reach with me.
My lord.
Night.
Yeah, please, your lordship. Lordship, I beg to mention item 27, your lordship. I have taken the concern of the other side. Also, I am praying for short accommodation in this matter. For today, your lord.
International school exemption.
Yes, yes.
A prayer is made by Mr. You are not there. On behalf of Mr. A. Saraf, Dr. A. Saraf, Learned Counsel for the petitioner, for an adjournment in the matter on account of personal inconvenience. Also, prayer is not objected to by Mr. S.C. Kal, Learned Standing Counsel, GST. Full stop. In view of the above, registry to list this matter again after 3 weeks on a date to be fixed. Interim order passed earlier to continue.
Can this matter be taken on 19, your lordship?
That week, sorry. Much matters are there. Registry to list this matter again on 12/3. 12 what to be seen? 12/3/2026. Interim order
Yes, your lordship.
passed earlier to continue till the next date of listing. Yes.
Pleasure.
Item 1.
Cooperative society sectors. Yes, Mr. Sinha.
Yes, my lord.
His projection is that the meeting was convened.
Yes.
AGM was convened, but it was not held because there was some manipulation made by the secretary and the election officer. And that is also reflected in the records. So, although the board is dissolved, it's not dissolved for their failure. It's dissolved because of issues beyond their control. Under such circumstances, whether not that nomination is gone. Now, whether they can also be entitled to file fresh nomination.
Fresh?
Nomination whenever the election is held.
Oh, that is, my lord, if once they default.
That cannot. But
Yes,
here
then
the
cannot.
default is not attributed to them.
That is, my lord, the registrar may decide, my lord, whether they defaulted or not there.
It's already there.
Because they have not elected, since meetings could not be held.
No. That their nomination, everything we are setting aside. They'll be entitled to make fresh nomination whenever.
Yes, my lord. As per law, as per.
You tell me what is the law.
Law is that once AGM is scheduled to be held, then nomination submitted, then arrangement of votes and all, so everything is there. But due to lack of quorum, AGM could not be held. So the ones there, those who have filed nomination, my lord, they have also become defaulter, my lord. Re-election of those members.
The three is that there were more than 123 within a period of 2 hours, around 123 people have registered. But because of the manner in which the registration was going on, the quorum was not possible.
Fulfilled, my lord, yeah.
And that meeting, the deferred meeting was also not fixed. So how can they be? Because it was not in their control. That was in the control of the
Yes,
department
of course, my
officers.
lord, but the mandate of law is that, there is a thing, is once if you are not,
Any decision on this point?
I have to search, my lord, I have to search, your lordship met just next week then, my lord.
Mr.
My lord, law is clear, my lord.
No, no.
And my lord, my friend, my lord, intentionally did not, my lord, a relevant document, that is election observers report.
I got it. I got it.
Observers report is clear, my lord.
Whatever it is, but
Yes.
the rule 39
Yes,
does not make any distinction between a fault or a default on the part of the directors.
yes,
It is general. If the board is dissolved,
yes,
which is an admitted fact,
yes,
then everything goes.
yes.
Yes, I got it,
But regarding disqualification, my lord, kindly I will refer 41.4, my lord. 41.4. That where a board fails to arrange, here the board arranged already for holding election of the directors or delegates as
You
the case.
just check up whether there is any
Yes,
decision on
it
this
is.
41.
And your lordship will find 8 may kindly be said, the 41.8. Director shall not be eligible for re-election if so specified by bylaw.
But that is different.
I will buy.
Heard
I will make
the
it.
council for the parties. Illinois Council for the parties have submitted that the matter be taken up on 23 to 2026, on which date they shall place judgments in support of their respective contentions. Prayer accepted, registry to list this matter again on 23 to
My lord, can it be on 24, my lord?
24.
Oblige.
24.
Oblige.
Yes.
May I please not? But sir, in these matters, this contract period is over, lordship. All these matters. But the thing is that my humble prayer is for this release of this security deposit money, lordship.
Why is the security deposit not being released to you? Why is the security deposit not being released to you? Hmm? Madam, it seems that you have not.
Nah, I have come prepared, but
Then come.
I have not avoided why this money was not released to me. But this petitioner is the highest bidder of the contract, lordship.
They have filed an affidavit.
Yes, yes.
In the affidavit, they have said
Earlier, the petitioner also filed it. to
Yes,
also
Mr.
be
Fact, my lord,
this and
the
propose this.
order was passed by the DFO and there's a statutory provision for appeal before the PCF.
Forget the appeal now.
Very well, Lordship.
Forget the
Since
appeal.
he's a defaulter, that's why security money was not returned to him.
See, he was, the initial agreement was 3,000.
Hmm.
But Sia said 1,000.
1,000.
So all money that was received from him was in, by calculation, 3,000, not 1,000.
Hmm.
What have you done after that? On the prayer of the learned counsel for the parties, registry to list this matter again on 23/2/2026. So, come up with your facts, with your pleas. Just standing there will not help you. Again, prepare.
All right.
Marvelous.
The other two cases have become infractions, but the
Infractions,
second
yes.
case will have a bearing on your prayer. Because the show cause notice is under challenge there.
Yes, so
Ah.
good notice under challenge.
Third case, infractions.
Yeah.
Because you will have no grievance there now. But 1 and 2, you have a grievance. Read.
All right.
Marvelous virtue.
And come out with the exact stand of yours. Whether, why, because this 3,000 to 1,000, then what did you do? Very sketchy.
But here's the issue is, Your Lordship, the mining approve, the plan which the petitioner has to.
No, there is no sand there. 3,000 sand is not there.
He doesn't say that, but the moment he takes over a mining contract area, Lordship, he has to submit a mining approved plan. Thereby, the mining approved plan, if there is 3,000 was there in the mining approved plan, he has to get it modified from the competent authority, Your Lordship.
But CR said 1,000. How can he go above 1,000?
He cannot go above 1,000, but the mining plan has to be modified.
Have you directed? Have you required him to
Because
modify?
of the rule, because the person.
Get the rule. Have you asked him to modify that? Any letter? No communication.
That's it.
Go through it.
Marvelous virtue.
I want madam to be out with all these points. You have to come out with these points.
Virtue.
Yes. None appears for the petitioner on call. Who is there?
Five.
Lordship.
Five.
Yes.
Lordship, in this matter, maybe at some time may be granted, Lordship. Time is not the misappearing.
On the prayer of the learned counsel for the parties, a last chance is given.
I think the
to
matter has become
make their
infractuous.
submission. It has become infractious
Cause
to make their submissions in the matter.
the
So, Mr. Learned counsel for the petitioner, Mr. Ardhar, learned standing counsel
Tribal
for
affairs.
the
tribal
Tribal Affairs the Department of Tribal Affairs is present. For the ends of justice, registry to list this matter again on 25/2/2025, 26 for further hearing.
my lord.
All right.
My lord, my name may be shown in the cost.
By reflecting the name of Mr. Ardhar, learned standing counsel, Tribal Affairs Department. See, your case is that a village council, which is a component of the act, has not been set up. Their plea is that is not required, because again, you are a fractured body. You don't have a contiguous area. A panchayat is already functioning. If this also comes in, there will be a clash of the same work that is been.
My lord, this has been done away with. By amendment, my lord.
Where is that amendment? That amendment has not come on record.
My lord, I am appearing for the first time, my lord. in this-
No. The amendment was done not for Tiva, for others.
No, Tiva also, my lord. It
Where?
was the 24.
Where? Show me.
My lord, this is the case of 2015.
Where is
The
that
ca-
amendment? I can only find an amendment for the other.
No, exactly, my lord. On the next date, I will place it before the court, my lord. The thing is that
Rabha, Missing, Thengal Kosari, Diori, Sonowal, all done.
Tiva also done. Village council got.
But in that letter, that exercise, this was not done because this case was pending.
It is also done.
Done. That's not the finish. You get it. Why we go to so far? 24 likhisu na? 25. 17 ko it video.
I will.
Just give me that
Yes,
notification.
my lord. Even at 2 also I can give, my lord. Today,
Very well, Lordship. We can-
2.
2 o'clock,
17.
my lord.
For further hearing.
All right.
Yes. Where is your affidavit?
My lord, here I am appearing. My lord, the thing is that here the plea of the petitioner is that, my lord, he needs a SC certificate.
ST.
Tribal.
And persons similarly situated like him are being authorized. Are being issued this certificate. Why not the petition?
And there is a report, madam, Annexure G.
Annexure?
G. Annexure G is the report which was conducted by.
And the tribal Congo has also.
Yes, yes.
The affidavit court.
Number of occasions our deputy commissioner issued direction.
ठीक है सर, मुझे WPT करना है, मुझे प्राइवेट रिकॉर्ड से करना है.
On the last occasion, my lord has made a pinpointed. What is the decision not to issue any, my lord, certificate, despite the fact that all other,
Which court?
my lord, perhaps, my lord, Justice Medhi, my lord, I think, my lord. Court's order doesn't reflect.
My lord,
Yes.
if there is an any,
The next date of listing, the learned counsel for the respondents shall invariably apprise this court as to why a scheduled tribe certificate as prayed for by the petitioner was not issued to him by the
deputy commissioner.
by the jurisdictional deputy commission, the district commissioner. Also, restrict to list this matter again on 23 to 2026.
Every minute.
24,
24 or 23, I don't want to available.
whenever it's up.
27.
27,
7,
so 27 to 2026.
I am obliged.
My lord, here the thing is that if there is a dispute, you should send.
You raised that dispute, Mr. Dar. You raised that dispute. You have not raised that dispute. All the documents are in his favor.
Still, my lord, when the DC, it has to be referred to the committee, my lord.
I'll do that. But you come up that he does not belong to that committee. Enough. That's the end of the matter.
Obliged.
Without a dispute, why should I create a dispute,
Exactly.
Mr. Dar? Yes.
A committee was set up, my lord, for the purpose of examining whether certificate
Mr.
is paid.
Murkhaista, if there is a dispute raised,
My lord,
then that has to go before the
Exactly.
state level scrutiny committee.
Exactly.
Enough. That's the end of the matter.
my lord,
You raise that dispute, we will consider. And if there is no dispute, issue the certificate to him.
my lord.
Yes. None appears for the petition on call. It is seen that with effect, said that during the last three listings of the present writ petition, that is on 28/1/2019, 22/1/2021, and 1/8/2022, there is no representation on behalf of the petition. So, in view of the said default, this court is of the considered view that the petitioners have lost interest in the matter, and accordingly, the present writ petition stands dismissed for non-prosecution. None appears for the parties on call. For the ends of justice, registry to list this matter again on 25 to 2026. Full stop. On the next date of listing, if the query as raised by this court, why the order dated 10 to 2026 is not clarified, this court may consider passing directions for having the competent authority who is required to issue the licenses in question to appear before this court. You are for AIDC.
AIDC, my lord.
Now the rents have been received by you.
But I do not have any instruction, all matter, my lord, I do not have to.
He wants to withdraw.
I have no objection, my lord.
If you have no objection, no problem. Your name?
DM Nath.
DM Nath, learned counsel appearing for the petitioner submits on instruction that the petitioner desires not to press the matter any further and accordingly prays that he be permitted to withdraw the writ petition. Prayer accepted. Writ petition stands dismissed on withdrawal. Mr.
Yes, that's man.
S. Das, learned standing counsel, AIDC is present.
Highly obliged, my lord.
You can inform your authority because there is dues, you can now proceed against him.
My lord.
None appears for the petitioner on call.
My lord, we have filed our affidavit, my lord. Para 8, they have already availed the remedy, my lord. If your lordship comes, my lord. In fact, challenging that notice, my lord, in fact, the revenue board also dismissed that, my lord.
No, that is a different thing altogether. None appears for the petitioner on call. Mr. N. Das, learned state counsel, learned government advocate is present for the state respondent. for the ends of justice, eviction matter,
My lord.
for the ends of justice, registered to list this matter again on. 18 to
2016.
2026. Today, what happened? Nobody is there. Everybody is confident that I'll not dismiss, maybe. What is the instructions in this, madam? Mr. Das, none appears for the petition on call. The learned counsel for the respondent pray that they be granted further 2 weeks time to complete their instructions in the matter. Registry to list this matter again on 26 to 2026. Can I'll give you the issue. Issue is very simple. These people are displaced persons from Bangladesh. So they were settled in the Central Destitute Home in Silchar.
Yes.
Now, this had a big area. Subsequently, the government started allotting lands to many people. And these people were put there in a shelter, and around 32 bighas are there. So they are praying that we should be given a rehabilitation. That's the policy of the government also. So if that be so, they'll have to be put up somewhere. They were given lands at different points of time, but they have not availed those lands, saying that there were disputes with the persons in the locality wherein they were sought to be accommodated or rehabilitated. Now, you have not taken up any plea against that. They are praying that it should be in the Central Destitute Home itself, they should be allotted. That may not be possible, but they'll have to be given something.
Relating to same issue, my lord, another writ petition is pending where I file affidavit. I can recall, my lord.
Can you get the number so we'll ask it to be
little,
listed?
little time may be granted to me.
Uh-huh.
Because subsequently,
Eight
there
wicket, yeah.
are 18 numbers of petitioners,
Register to list.
same issue, same prayer. has
Along
been
with-
made.
Along with WPC number so and so. Maybe there would be. You get it.
Subsequently, some people
I
also,
just want to know the government standing.
probably these petitioners and those petitioners may be same. also.
Maybe same also.
GA
Because these people their back is behind to the wall. They are left with no other alternative.
Officials at that particular filing of that writ petition, officials inform me formally there is some political nexus between that dwellers, my lord. So they cannot express it in a written form in affidavit, but whenever they try to rehabilitate them, they object it, my lord. On the other hand, moment some surmises and conjunctions arises, they come here and file writ petitions. Probably there are a group of peoples, my lord.
But see, they are also not living in a manner, dignified manner. They are living in small
They
spaces.
are time to time they are tried to get homes
that's
and
what I told
lands,
you.
my lord.
Okay.
But they are objected.
Along with WPC number so and so. So and so. Name registered to reflect the name of Miss M. Borma, learned government advocate in the cause list for the state respondent. You get me that? We'll see.
Lordship, little time may be granted.
No,
I will
please
print
give it
out.
to her. No problem. Yes, madam.
Your Lordship, I'm from the respondent side. I'm from the respondent side, Your Lordship. The petitioners has to file the substitution.
They have not filed a substitution. In the present writ petition, full stop. This court-wide order dated 21/11/2022 had recorded the submission of the learned counsel for the petitioner that the petitioner is no longer in the present world. Also, the learned counsel for the petitioner had sought for time to file a substitution application. Also, no such application is found to have been filed till date. Also, in view of the above position, there being none to press the present writ petition, the present writ petition stands dismissed for non-prosecution. Miss,
Sir, I'm on behalf of foreign on behalf of Rajesh Batra.
you are for the respondent, madam.
Yes,
I have dismissed the writ petition, no prejudice to you. Miss so and so, Miss,
Sir, but
Your name,
Rudrakshi
Rudrashi
does.
R. Das, Learned Counsel, appearing for Mr. R.K. Bhatra, Learned Counsel, representing the respondent bank, is present.
Lordship.
Ma'am, when there is no substitution, there is no one to take the matter forward. That is why I have dismissed for non-prosecution. If they come back, we will restore it. Ma'am?
I'm appearing for the respondent bank, Your Lordship.
Nothing is there. Why the people are not appearing? Was the matter taken up to its logical conclusion? Criminal cases?
Lordship, that part, Your Lordship, the police official, they will be able to apprise this court, Your Lordship, the state.
None appears for the petition on call. There was no representation on the earlier dates of listing, that is on 2/5/2025, 15/5/2025, and 10/2/2006. Also, in view of the above, this court would presume that the petitioners have lost interest to pursue the present writ petitions. To pursue the above noted writ petitions. Also, accordingly, the above noted writ petition stands dismissed for non-prosecution. Also, interim orders passed earlier stand vacated. I think that money they have got back.
Lordship.
Because it was freezing of bank account. I
Freezing
think
of
they
bank
got
account.
back. 14, 15, 16, huh?
Obliged.
Ask the matter for the time being, Your Lordship.
I mean, would be impossible today.
Later,
We had kept this matter, I had rushed down so that I can hear this. Mr. Bhatra, that matter, there is no representation, no substitution, nothing.
my lord.
So we have dismissed for non-prosecution because there is none to press the matter now. If they come back, we will restore it.
Obliged.
Your junior was a bit apprehensive.
Yes, yes, ma'am.
I told her not to worry. This is nothing to do with you.
My lord, I was just stuck up in jam.
No, it's okay, Mr. Bhatra. I've
Right.
recorded her name. Shall I record your name?
My lord, as your lordship.
R.K. Bhatra. R.K. Bhatra, Learned Counsel. Yes,
Deeply
sort of.
obliged.
Any other than my lord, then in that case.
No, I'm ready to hear this matter. Small point.
Mr. Gogoi is also in legs in another court, my lord. Maybe, may not be, my lord.
The matter was taken up, was fixed today for further hearing. However, when the matter was called, both the Learned Counsel, arguing counsels are not present, and a request has been made for an adjournment in the matter. So, in view of the above, the matter stands adjourned by 2 weeks, for 2 weeks. This matter shall not be considered as a parted and or tied up matter with this court any further.
I am for the respondent, my lord.
What is this? If you have not, I forget.
Lordship,
Forget
if I
it.
may.
Yes. Yes.
I am on behalf of Mr. Mintu Sakia.
Whoever it is, what happened to that work compensation? Work compensation case, you have got your money
When compensation has been pending, Your Lordship.
pending. Okay, that's whatever you get it there.
Lordship, earlier on 27 December 2021, a sanction letter was issued to the petitioner, Your Lordship.
Hmm?
Sanction letter was issued to the petitioner.
Then what happened?
Then due to changing of her address, the amount could not be released.
If you are pressing this writ petition, I'm dismissing it. But if the government wants to give it to you, I'll not come in way. Madam,
Lordship, we don't have file. my
a
lord.
private vehicle, a driver of a company driving a vehicle, that vehicle getting in, meeting an accident without any other involvement, that is capsized.
Like-
And the man dying, and you are now giving him ex gratia. Very good. Why should I come in?
Lordship, we don't have any file because I'm having the court file, my lord. Communications are yet to verified, my lord.
Miss, Madam, your name? Huh?
Doctor.
Our Dr. Learned Counsel for the petitioner submits that the respondent authorities have processed the matter for release to the petitioner, her ex gratia. So, however, whether the said amount has been released or not, the said instruction is not available with the petitioner, with the Learned Counsel for the petitioner. Accordingly, she prays that the matter be taken up on 25 to 2026, so as to enable her to apprise this court about the developments taking place in the matter. Ms. M. Borma shall also receive instruction.
Lord,
Deputy Commissioner Dima Hasa will be under you.
Only Deputy Commissioner.
Deputy Commissioner.
Rest. we are-
From the Deputy Commissioner Dima Hasa District, Haflong, about the status of release to the petitioner, the ex gratia amount involved. Also, raised it. Huh? 25 likhi sune?
My landed
Raised
friend
must
may
be given.
provide a copy of that sanction order along with a writ petition, my lord, so that I can have the
Raised
instruction.
to list this matter again on so and so, reflecting the name of Ms. M. Borman, learned government advocate, appearing for the respondents. If you are getting it, madam, we are not coming in between. You take it. But otherwise, you are not entitled to that. The
Seems
government wants to
seems
give you, government is mighty able, they can do anything. Why should we?
whole concept lies because that public place, my lord. Everybody is trying to explain on that, my lord,
Yeah.
as there is no such revenue guideline regarding to that, my lord.
It is not maintainable. Because that public
Actually,
public
not.
area is again in a hit and run case,
My
maybe.
lord.
Third party, maybe. But if it's identifiable, the vehicle is identified, you have an option in the before the MSCT. And if he's an employee,
It is
workman
currently
compensation.
by our coordinate bench also, my lord. That
I'm
Manita
holding the same view.
Monisha case
I'm only holding that view.
also passed, my lord.
But now that you are giving it to her,
My
why
lord.
should I come in between a poor lady? Let her get it.
My lord. Bless you. Thank you, my lord.
Pada hearing good. Yes, Mr. Biswas.
Okay, with regard. to
Equity
the
deposit
release
not
of
released.
security-
Yes.
No, file my affidavit in the
Yes,
matter.
you have filed your affidavit. Yes.
Disclose the reasons out there. Malab, they have not applied in the prescribed format and with the
Fine.
proper documents, my lord.
Okay, if your lordship goes through the terms of this, it was the duty, I have highlighted the GCC can be looked into by your lordship, that I have given the
That is
extract.
the procedure followed in each and every contract. On earlier occasions also, my lord, the same contractor has given it in other contracts, my lord.
Yes, why don't you give a no claim certificate? You have
Why?
put your money
The arbitration award they have released.
released and plus some other, what more is required? Any further amount
I
to
don't
be?
No, nothing.
Why
Then
This
you
is
so
the,
adamant, my lord?
we can, it can be disposed of with the thing that.
Yes.
No, we are not disposed. You give it today.
Okay, I will instruct.
Mr. P. Sharma, learned learned counsel appearing for the railway submits that the security deposit of the petitioner was not permissible to be released inasmuch as the petitioner had not submitted an unconditional apostrophe beta, no claim certificate. He submits that the said certificate, any other thing, any other,
In
only
the
that one?
proper format, my lord. A proper application accompanying that.
He said no claim certificate is submitted in the proper format along with the application by the petitioner. The railway authorities would release the security deposit amount of the petitioner. Security deposit and earnest money
Performance guarantee.
Performance guarantee.
Earnest money gets converted into.
and performance guarantee
performance-
presently in the at the disposal of presently lying with the railway respondents. Mr. A. Biswas, learned counsel appearing for the petitioner submits that he be granted a week's time to enable, to facilitate, he may grant a week's time within which the petitioner shall approach the railway authorities by submitting a no claim certificate, no claim to apostrophe certificate along with proper application in the due format. Also, the application being submitted by the petitioner in the due format along with the no claim certificate, the railway respondents within a period of 15 days thereafter shall release to the petitioner his security deposit along with the performance guarantee. Performance guarantee. Full stop. Registry to list this matter again on 10/3/2026 for further hearing.
Highly obliged.
You get it done, we'll dispose it of.
Yes.
Why should we just dispose it of? You come back again by contempt. Why are we increasing cases? Mr. Sharma?
Yes, definitely, my lord.
May I please, your lordship? I am appealing for the perfect respondents, your lordship. Lordship may kindly take up this matter on next week, your lordship. My senior
Who
is,
is for the,
my senior is not well, your lordship.
no, who is your senior?
As Borthakur, your lordship.
He is not for the private respondent.
4 and 5, your lordship. Any date on next week, your lordship.
A prayer is made on behalf of Mr. S. Borthakur, learned counsel for the respondent, for an adjournment in the matter on account, on the ground that he is indisposed. Prayer is not objected to by the learned counsel for the respondents. For the petition. Petition. Prayer is not objected to by Mr. K.U. Ahmed, learned counsel for the petition. So accordingly, registry to list this matter again.
24, my lord.
On 16/3/2026.
My lord, 16th.
3. Any problem?
My lord.
No, if you have any problem, I can change it. There is no problem.
Okay, my lord.
Obliged.
Wait, please, your lordship.
Mr. Borthakur,
Yes, madam.
you're only pleased that the two persons from him,
Yes.
the owners, landowners of the land,
Yes,
which he had taken on lease, had not signed on the lease deed.
Yes, ma'am.
They have signed on the lease
No,
deed.
no, there are other co-owners, madam.
Yes.
Yes.
The circle officer says only two.
But no, madam, in Dagdamar, madam, there are other 5 co-owners, madam.
Where do I
Yes,
get
yes.
it? You have filed an affidavit.
No, madam.
Then why are you making all this, please? You cannot. The documents which have come on record shows only two.
Page 92, my lord, kindly see, my lord.
They're co-pattadars, my lord.
Same thing, my lord.
No, my lord. That is
Partition of the land has been.
No,
taken
my lord.
place.
no partition is not taken.
Esmali Patta.
Yes, madam.
Then
Then still they're pattadars, my lord. They're not.
treated as it may. Mr. Lal, they will also have to give a no objection.
No, my lord.
Not required.
Not required.
So show me the law.
Lordship, page 38 is the document that is
I am
required.
holding it. Yes.
Page 40, Lordship can see. Kharsa Khatun, any other other equivalent revenue document or certificate obtained from revenue official.
No, where is that, that every owner should also sign the lease deed? There is a
That is
condition somewhere.
106, my lord. Page number 106. 106, Lord. Last part. The land should be available with the applicant on the date of the application and should have minimum lease of 19 years and 11 months as advertised by the respective community from the date after the date of advertisement, but not later than the date of application. If the offered land is on long-term lease, there are multiple owners, my lord. Then lease deed should be executed by all co-owners of the offered plot. Having leased it is not executed by all co-owners, such lease deed should not be valid. The co-owners and co-pattada, they're playing with these two terms.
Now, where is the identification of your plot of land? How was it identified?
Lordship, there is a trace map, my lord, there.
No, was there a partition between you?
No.
Where is that
Part-
partition? That-
Partition is not required.
then that whole area is one in the eye of law.
No.
You may have different areas there, but it's one patta.
But once I purchase the same land, I become the owner of a particular square feet, my lord, and particular land with demarcation of boundaries, my lord. That is there, lord.
Yes, what do you want to show me from this?
No, but this is a complete set of, my lord. See, my lord. My lord, gone through, the lease deed, my lord. It has no boundary, my lord.
Okay.
Section 20 of Registration Act says, my lord.
Okay, forget it. Where is this? What do you want to show me from this?
Well, kindly see page 9, internal page, my lord, bottom, my lord.
Hmm.
The boards, are, my lord. Own means, my lord. Note 1, my lord.
Hmm.
Own means having ownership by your registered, sale deed, registered gift deed, or title about a property, or registered long lease as per individual OMC norms in the name of applicant, family members as defined in 4.6 and 4.6 No, but he is not an
Okay,
exclusive
where is
owner,
the
my lord.
lease deed?
Yes, my lord. 50. The first one is at 52, my lord. Now, kindly see 54. He says, the lessor says, the lessor is an absolute owner, kam pattada, my lord. Without partition, my lord, how can he become the owner, my lord?
Where is the description of this plot?
No, my lord. Page 56, my lord, there is no
Yes.
description.
That's
Section
page
21
56.
says, but it has to be.
56,
Page 62, lordship.
62.
Longitude and latitude, my lord.
Who has prepared this?
The circle office, my lord.
Huh?
No,
Where do I get the endorsement of the circle officer?
no, my lord, it's
Not, there is no endorsement, my lord. But this is not the ground, my lord, on which they have rejected my claim, my lord.
They have rejected your claim on the ground that the other co-pattadas have not
Lordship. Yes.
signed.
Yes, lordship. That is the only ground, my lord. Once, my lord, and they say that we will accept any document from the
Any
revenue.
interim order here?
yes, my lord.
Lordship. They say that we will accept any document from the revenue.
Yes, Mr. Uchaji.
Now, kindly see the
If
court
there
has
is
passed
no-
similar order, my lord.
If it's an Esmali patta, then
Has to be treated as one.
one. And everybody will have to give their no objection.
Otherwise, tomorrow,
Some,
one object, what will happen?
The coordinate has passed this order, my lord. We also, my lord, there are multiple owners, my lord. There are 9 and 10, my lord.
yes, we are in respectful agreement with this.
Lordship.
Co-pattada's signature not there, no objection certificate not there. Because they are not your family.
Yes, my lord.
Two things only in my submission would be, lordship, that lordship may consider that.
Hmm.
One is, my lord, this document says, my lord, that they will consider any document from the revenue, page 40, if your lordship takes up.
Hmm.
Documents from the revenue officials. Now,
Mr. Lal,
lordship,
we agree to everything.
lordship.
But tomorrow somebody of that, one of
No,
those
then let
pattadas
them-
come up
Let them.
and say that this plot, this cannot be
Yes,
established
Yes,
in this
lordship,
land.
lordship.
That's the end of the matter. That is
Lordship.
the reason.
I agree. Even if I agree with your lordship, my lord, contention here, my lord. Lordship, that let them reject it on that ground.
Where is your rejection?
My lord, first one is 84, my lord.
98 is the
First
rejection.
one is 84, my lord.
Huh?
First one is 84. After representation, we again rejected his claim also, my lord. Page 84, my lord.
The final order is, my lord,
Same thing.
Yes, yes, same thing.
all co-owners have not agreed. So they say the co-owners, my lord, lordship now, by
print of this order, my lord, co-owners will become the co-partner. Suppose this building belongs to the High Court, my lord. Now I purchase this room, my lord, from the High Court. High Court does not remain the co-owner of this room, my lord. I become the owner, and I don't become the co-owner of the whole High Court building. It still remains with the High Court, my lord. This is my submission, my lord.
And if you say
If I want
setting
to
up a
take it, I
petrol
can say
pump
it,
here,
Lordship.
setting up of a petrol pump here,
Yes, lord.
and this room was the other party's High Court, this
Yeah.
was somebody else.
Lordship,
Say,
lordship.
this was District Court.
It is
District Court sold the land to you, that part
that part.
to you. Now, but it is one patta.
Lordship.
Now, if the High Court says you cannot do it because this is my, I'm also having a
Yes,
right
ma'am.
because this is my patta,
Can
you
the High
can't
Court-
do it.
No.
Can you without a no
Yes,
objection
cannot.
do it?
Suppose in a Azmali land, if a lordship says, my lord, then there can be no permission in the Azmali land. If we go by lordship,
That's
view
what the
on this,
Supreme
my
Court says,
lord,
but it's a forceful possession, my lord.
there will be no permission, my lord, on an Azmali land, lordship.
Okay, anything more?
No, that is my submission. I'll leave it to your lordship discretion. That they say the revenue documents, they say any documents from the revenue authorities. We have produced the revenue authority submissions. Now thereafter, my lord, we did not never say that it is because of the co-patta land will not be considered. Co-owner was the word used. They are not, there was no co-owner. That document is there, lordship. No further, my lord.
Okay. Heard Mr. A. Learned Counsel for the petitioner. Also heard Mr. S. Thakur, Learned Standing Counsel, BPCL, and Mr. A. Bachaji, you are paying.
Please, Honorable.
Ms. M. Borman, Learned State Counsel for the state respondents. So, hearing, I've heard the Learned Counsel for the parties at some length. Registry to list this matter again on 17/2/2026. If you have any judgment to that, I think give me. Otherwise, I'm dismissing the report.
May I give the two judgment of the co-partner and co-owners, my lord?
That is it.
Ah. 2009.
One case I remember I appeared. Forgot that.
What
I
is the
appeared
case
that
of-
side.
Yes.
2009-7-444.
I-
Will try to satisfy me on that. This is the only ground I have. Lordship agrees, lordship disagrees. That is, I leave it to lord. That co-owner, they are using the word co-owner. Now they cannot change it to co-partner. And here,
2009 is
what lordship find
9,
is
my lord.
co-partner.
Para 7, my lord.
I'm already.
It is, no?
17. Lordship, one more prayer, Lord. Can it be 19, Lordship, instead of 17, Lord?
No problem. 19.
19, Lordship. I'm afraid.
Time being. Unless I wants time being, my lord.
Possible,
Starting timing today impossible.
Mr. KP Pathak is in court one, he is in Lakes.
Today difficult.
Kindly accommodate, my lord. Kindly. yes.
Madam, I'm not here. So I want to, if required, because I'll have to leave early today.
Leave
I'll have
early.
to sign orders. I'll have to dictate.
Okay.
It'll take some.
Then, my lord, that will be
A
given
date may be
because this
fixed.
court number 1. So
Is in
my
old building.
submission will not be a years to come. Matter is
Their
to
case
dispose
is
of-
that it was an industrial line.
Yes.
That was given to for commercial use. Your case is that no, I had applied, you had come, done your say, but you did not go ahead. Now, if you, in that circumstances, whether this
One
huge
circular
penalty,
was there.
so
One circular was there.
Ah.
They are also not to the knowledge, and it was not within our knowledge.
so that
Therefore,
a
they
penalty that
partly
has
allowed, the appeal has partly allowed.
partly allowed because
Partly.
you came up before this court, matter went back. We'll hear, we'll let Mr.
Yes.
Pathak come. I'm here till 1. Let's
But yes.
Mr. Pathak come.
Much obliged.
Okay, my lord.
Provided the list is not over, we are here.
I'll wait, my lord.
My lord, in last occasion, PW has taken time to file affidavit on 2 times, my lord, 2 occasions. But till today, they have not filed. But I am, my lord, hankering for money that has been, my lord, required against my land. It is since 2023.
The money that they have agreed also have not been released to you. 4 crores
No,
something.
that cannot be, my lord, because they have, this is a direct purchase. Direct purchase, they have signed. Now they are saying that it is land will is reduced, but that cannot be deviated, my lord. This is the thing.
This is
my lord.
direct purchase.
Yes, my lord.
Who is appearing for the PW. Mr. Mohammed, you are appearing for?
He's a private party, my lord, contractor. I have no, my lord, because my fault is this, my lord, I have given the NOC one. This is my fault.
I have already completed my fault. This time,
Oh, you are that builder, that
He's a
contractor, road
contractor.
contract.
He's contractor. He paid the NOC, I issued the NOC on the good faith, my lord. This is the only.
Where
my
is the
fault.
PWD? Mr. Sharma?
PWD name is shown, Lordship.
Okay, what is your stand?
My stand is that, Lordship, that after calculation, the amount which is found to be relevant at that point of time, that was, we are agreeable to pay that much of amount, Lordship. In our affidavit, we have stated categorically.
Have you filed a reply to this?
Yes, my lord, I have filed.
So it's basically the,
But that order is
you are
there to
paying
file a
4.84. They are
This is total, my lord.
some 4 point something.
No, this is theirs. They are saying, yes, they are now going to show that they are going to pay. And when it was 2 lakh some 2 crore something.
273,03,174.
And his claim is 5.8.
Yes, my lord.
Pleadings are complete because it's a deputy commissioner who has to pay you.
Yes, my lord.
The direct
purchase, my lord.
direct purchase was with whom?
Madam, this is the deputy commissioner representing one and another side is a.
So it is between you and the deputy.
Yes, my lord.
The
Agreement is this.
pleadings have come on record.
Yes.
We'll hear the matter.
Yes, my lord.
Heard Mr. P. Monto, learned counsel for the petitioner. Also heard Mr. H. Sharma, learned standing counsel, learned additional senior government advocate appearing for the state respondents, and Mr. K.U. Ahmed, learned counsel. K. Bhuya, learned counsel appearing for the respondent number 7. Full stop. It is submitted that the pleadings in the matter is complete and the matter can be taken up for final disposal, final consideration. Full stop. Accordingly, give me a date.
My lord, was short. I'm giving money because of these things.
Accordingly, registry to list this matter again on 26/2/2026.
My lord.
For admission and
Well,
will be made to dispose of the matter.
Lordship, may I pray in the first week of March, Lordship? Lordship.
5/3. Endeavor would be made to dispose of the matter on the next date of listing.
My lord. Petty definitely. Okay. Particular asset.
The district malaria officer, working since 14 years. The 2 cases which I have relied on, I have given the copy.
This is not parted before me.
No, for further hearing, your lordship has seen.
No, it's not there.
Last occasion, your lordship has seen for further hearing. You have heard the matter. Yeah. Order dated 30/1/26.
30. I do hear it.
May I hand over?
क्यों ना?
Maybe in IA.
I hate to order. Agree. So it's okay. Yes.
My lord, may I just say this is there was an advertisement, your lordship takes at 4050. There was an advertisement, page 27, dated 13/4/2010. Inter alia for 15,
What is the date of this advertisement?
13/4/2010. For 15 post of district malaria officer under regulation 3I. All the petitioners were selected and they were appointed initially for 4 months on 29/12/2011.
This is district malaria office.
Right.
They were initially appointed on 29/12.
Yes. And they have joined on 3/1/12. And thereafter, my lord, services were extended from time to time. Sometime after 8 months, sometime after 9 months, sometime after 7 months. This your lordship will get it at Annexure 5 series. For example, my lord, your lordship takes page 41. Page 41, it is after 9 months. Similarly, my lord, page 42, it is after 7 months.
Got it.
My
Then
lord, this is there. Then thereafter, my lord, they did not, there was a DPC, my lord, page 50. DPC recommended their regularization. Page 50. We start from page 50, page 50 and 51. 51
this
below, my lord.
11/12.
5. Below, my lord. District Departmental Promotion Committee also appointed as there are 19 posts of district malaria officer lying vacant and 9 numbers of district malaria officers are working under regulation 4D and only 5 are working on regular basis. The Departmental Promotion Committee therefore recommended so and so for regularization.
Now, how can you be under 4D?
It is actually 3F, my lord, but
The constitution of the MHRB, my lord, Medical Health and Recruitment Board. The persons appointed under 3F.
Are 4D there?
Yes, my
now
lord.
4D, yes. Now not under APS.
No, under APSC.
When was this conversion made?
2017 or 18. I am giving you the exact, my lord.
My lord, in IA para 8, I'm not going to the writ petition. In IA para 8, we have stated the details of the working of the petitioners, how they worked.
Yes.
In IA 2877, public 25, I have given, my lord, in paragraph 8, details of the working of the petitioners, including the documents, which they have not denied.
MS
After 20, yes.
MSRB was constituted on, my lord, October 25, 2017.
MS?
Medical and Health Recruitment Board, Assam,
2017.
2007, 25/10/2017, my lord.
You are referring to page.
Para 8, page 11 of the IA. My lord, because after, my lord, May 25, 24, they have not been paid salaries, although they are working. Now they are saying since your extension is up to May 24, so you are not entitled to get salary, you are not entitled to work also. I've given the details of the working of the petitioner applicant number 1. Paragraph 8, applicant number 2.
And they are not getting their salaries from?
From May 24. And I have shown, my lord, after that also we are working. And normally, my lord, the extensions are passed after 8 months, 9 months. So in that, this circumstance.
You're working as on date, no, you have now been asked to go.
After the interim order, they have not allowed me to work. So therefore, the court Learned Single Judge directed my lord to allow me to work. So they have filed an application for vacating. So this is the position.
Okay.
Now they have passed. We came before this court, page 58. Your lordship, can you see? Because we did not get salaries and all, we came before this court and writ petition, the earlier writ petition, and court directed you consider payment of salaries and regularization, etc. Page 59, your lordship will get it. It is item number 24. In the interim, considering that the petitioners are continuing as district malaria officer, as your lordship got it, page 59. Although there is no specific extension order of their services, provided that the respondent authorities may consider the extension, regularization of their services, as well as payment of salary, take into account the recommendations of the Departmental Promotion Committee. Now thereafter, my lord, they passed this order, page 66, saying that you cannot be regularized in view of Uma Devi case. Page 66. Only regularization, they have not said anything about payment of salary or their service.
What happened to this writ petition?
This writ petition is item number 24. 25.
No further order has been passed there.
No order.
There is this interim order is in this petition.
In this petition. In this petition, in their IA, my lord, your lordship will kindly see. The order dated.
Yes, Mr. Das, what is your case?
So there was a stay order of that interim order. Then there is a interim order directing to allow me to continue in service. That your lordship will get it at.
Okay, where is your
7/11/25.
7/11/25?
11/25.
The order of this.
In their IA, your lordship will get it. They file IA for vacating the stay.
I've seen that.
That order, page 35, 46. Page 45.
Ah, 23/7/2025 order was reiterated, right?
Yes, an order dated 7/11/25. And they have filed this petition for vacating. Now, my case is, my lord, I'm relying on this, that was for a particular period. This 2015, my lord, OM, page 14, page 104.
I think we have already discussed on that.
Yes. There are also 9 years to so and 20.
But that was a one-time measure that is gone.
One-time measure, my lord, similar measure should be also drawn up for the petitioners also, my lord. Why only for them? Because rightly or wrongly, they have, the petitioners have continued in service. And they have been allowed to continue in service. And therefore, my lord, the benefit of that, this is one of my submissions, my lord. And Jaggu case I rely on because the Uma Devi is not applicable. Jaggu and Dharam Singh, my lord. These two judgments I have already given.
Yeah, Chief.
That, but there I say, my lord, at least.
One query.
My lord,
When you had applied,
apply it.
you knew that this is this is only for 4 months. With the further stipulation that you will have to appear through the EPSC to
Yes,
get this.
we appeared and.
But
we
you
did-
plugged.
We did not, ultimately the select list was set aside by this court.
It does it, man.
Yes. But we
So-
continued in service, we were allowed to continue in service.
Naturally, because there was a death, but you knew that you will never be regularized. Then,
Never be regular, but they continue.
and have you
in
taken a
service.
plea that you are not don't require this post again?
Yes.
In the writ petition, affidavit?
No, their DPC proceeding itself says the posts are there.
My lord,
You have not taken that plea here?
Posts are required. May I just, their main plea is that since you.
yes, my lord, that was not taken, but in terms of the directions by your lordship, my lord, on last occasion, the instruction
That cannot be brought by way of a paper. Sorry, we will not accept that.
no, because as your lordship directed me to obtain this.
Now, there is an
specific-
interim order from this court
Yes, my lord.
asking that they should be allowed to continue.
My lord, kindly see what was the interim order, my lord.
No. Subsequently, it was clarified.
No, my lord.
You come to 23-7.
Yes, my lord, 23-7, my lord. My lord, this order says, my lord, page 34 of my IA, my lord, considering the fact that a coordinate bench by the order dated 10/4/2025.
When did you file this IA?
My lord, this IA we have filed on 15/12/2025. So it says that 23/7/2025 order says that, my lord, considering the fact that a coordinate bench by the order dated 10/4/2025 passed in WPC number so and so already directed the release of salary and consideration of the cases of the petitioners for extension, and also in view of the orders passed by the DPC as well as the communication issued by the Director of Health Services, let the order rejecting the regularization order dated 4/7/2025, that is the speaking order, as well as the all other consequential order that may have been issued be not given effect to till the next date fixed.
So this order, you had no grievance. This order, you had no grievance.
My lord, now in the
Then on 7/11/25.
No, my lord, we have prayed for vacation of this order also in this.
Now,
Yes, my
at
lord.
that point of time, you did not have a grievance.
Yes, my lord.
Because this is of 23/7.
Yes,
You had no grievance. So are you not in contempt of the order?
My lord,
Then
kindly.
comes 7/11.
Yes, my lord.
7/11
My
is
lord,
nothing but reiteration of 23/7.
Yes, my lord. Now 23/7/2025 order stays the operation of the speaking order as well as all other consequential order. But my lord,
And where is your plea?
kindly see
Mr. Bora, where is your plea in the cancel in the regular in the speaking order that these posts are not required?
Yes, my lord, that is not there. But kindly consider letter dated 18/3/2025, page 21, my lord. Of my IA, my lord. IA number 284. Because this order, my lord,
This is a general order, Mr. Counsel. This has got nothing to do with this.
After this order, my lord, they were not
You
allowed
have not taken the plea that these posts are not required. We are abolishing this. Have we abolished this post?
Abolish, my lord. It was a temporary 3F appointment, my lord.
No. 3F is against a particular post, Mr. Counsel.
Yes, my lord. Yes, my
And you have not abolished those posts. Yes. So that means you required them. You have not taken that plea anyway.
Yes, my lord, but as your lordship directed me to obtain this instruction, my lord,
That is afterthought.
your lordship on last
Where is
occasion-
that material to show that this was the ground when you had issued the order? That is not there.
Yes, that is not there. Yes,
So we are setting it aside. We'll have to interfere with that.
but my lord, 3F appointees, how they can be regularized, my lord?
If you want, I'll answer it, no problem. I'll see to that they are regularized. Following Supreme Court decisions. The only thing, they are working against a permanent sanction vacant post.
Yes.
Enough. There are decisions of the Supreme Court.
But there are decisions that 3F appointees cannot be regularized, my lord.
That is gone now. That will be superseded by the Supreme Court decision.
Jago.
The DAS has not placed that. Not Jago. Jago and all are gone.
Yes, my lord.
Latest is there.
Dharam Singh.
Justice Vikram Nath. Recent, last week.
Vikram, yes.
Huh?
Vikram Nath. Vikram Nath.
No, the judgment that I am talking about is last week.
Last week, I think, 25. No, not last week.
That is on the specific point, contractual appointment, but against a sanction vacant post. Supreme Court said nothing doing. You will have to regularize. I'll have to apply that law. Because then nowhere you have taken this plea that we don't want this man, we don't want these people. Not taken. This page 21 is nothing. It's just a.
If your lordship gives me the judgment, my lord, let us go through it. Then your lordship may take up after 1 week, my lord. The latest judgment. Let us go through the judgment, my lord. Your lordship may take up the matter after 1 week, my lord. The judgment is there.
And your case is that you have done it only in 21, following 21, right?
Yes, my lord. Yes, my lord.
Then that is the end of the matter.
My lord.
Sanction post. Is decided on 19/8/25.
No, Mr.
Another is there. Yes.
There is the latest one.
I'm working on regular post.
Contractual, but working on regular post. Supreme Court said that no, you will have to. Just place that.
Yeah, please.
I forgot to get it yesterday. I thought
I'll
of
post.
finding it out, but somehow I missed it out. But the learned counsel for the petitioners. I've learned counsel for the parties. However, hearing remains inconclusive. Registry to list this matter again. We are not putting it on a longer date. We'll have it on 24th. 24th of Buddha Sunday.
Yes, my lord.
24th.
Yes, my lord.
Oblige.
Hold.
Oblige, my lord.
I'm trying to get that judgment. I think I have it. Just give me a moment.
Bholanath versus State of Jharkhand.
When is that judgment dated?
T01.
Huh?
30th January.
30th January, maybe. That's the one.
Will
Just,
provide-
can I?
Only citation is there. After judgment is not there.
No, I'm having it with. The principle remains, but the citations somehow.
Nowadays, earlier we used to read books. Nowadays,
That's
all
the
in
problem.
mobile.
So thus you have hit the nail in the coffin. That's the main thing.
Get it.
Bholanat versus State of Jharkhand. If you have that judgment, it's a civil appeal. That number is not good. 2026 INSC 99.
Okay. Please complete my edition. Hold on. Oh.
In the present case, the appellants were appointed by the respondent state against sanction post, with the engagement being described from inception as contractual in nature. Terms and conditions governing the engagement stipulated appointment would be for an initial period of 1 year, extendable thereafter subject to so and so. So that was the factual background. Then it goes on, unconsignable, Projonat Ganguly, everything discussed. And then finally, the respondent state was not justified in continuing the appellants on sanction vacant post for over a decade under the nomenclature contractual appointment and thereafter denying to them consideration for regularization. Abrupt discontinuance of such long-standing engagement solely on the basis of contractual nomenclature without either recording cogent reasons or passing a speaking order is manifestly arbitrary, violative of Article 14 and of the Constitution. Then it goes on, passes direction, says that High Court orders set aside, direction given to.
And in this case, my lord, another very difficult things from the state government is that the last extension order is up to May 24, and thereafter there being no extension order, your work goes. And in paragraph 8 of the
No, that is a wrong perception made by them in terms of page 21 order.
that is what this is the only plea they are taking, that there is no extension order. All
So, can you just go through that once and then make your submissions?
on
You also go through.
Yes, my lord.
And Mr. Bora,
Yes, my lord.
if you have a genuine ground that you don't require them, they are not going to come in between. But unfortunately, that is not the ground on which the orders are passed.
That is,
You can do one thing. You can withdraw these orders, allow them to come back, take a fresh decision in accordance with law. We'll
Yes,
not
my
come.
lord.
Otherwise, if we have to come, we will have to judge the order on the background the order has been passed. Your
Yes, yes.
subsequent things will not come.
let the justice
Yes, ma'am.
go from this court, not from their end. Their end they will never give, because the manner in which they are saying now that despite taking their services for 1 year, they are saying there is no extension order, so they are not in service.
Mr. Sharma, next day, ask the petitioners how the work of the post, because this is not a,
Give it details in paragraph 8.
they are not
Yes.
working as on date.
After the order passed by this court, after the interim order passed by this court, they were not allowed. So therefore, we filed the second writ petition.
So they are not allowed today.
They are
How
not-
are the works being managed? Because this is not a post which can be just, maybe there is no rains, there is no problem. Once rains come, there will be problem.
No, my lord, because the data shows that, my lord, for last several years,
Now additional charge has been
except
given
two
to some other
districts,
person.
Just get those orders.
yes,
Just
except
get me those orders.
except two districts, my lord, Kukradhar and Chirang, my lord, in other districts, my lord,
Malaria organization has been closed down.
not closed down, but
Then?
they don't have any work because the cases are not there. That's
That is not the
it is
speaking
there
order.
in the cert, my
It's
lord.
not only that, there are many other activities involved.
Leave
Now
one
the rains are
evidence.
coming, you will have to you will have to remove the jungles. Wherever there is water stagnated, you will have to put medicine. It's not something that when malaria detected, malaria officer comes in. No, it's a long. And till today, vector-borne disease, that organization is still continuing. So you better,
Yes, my lord.
you get me those.
I'll take the
किमान तारीख issue?
24.
24 will do?
Your lordship will not leave it to them. my lord.
No, no, for that you give me
Yes,
materials.
I'll give. And speaking or order itself is only on the basis of.
I'm telling you today, I'm ready to interfere now only.
Let it come on 20.
Obliged, my lord.
24. Wait. 12, wait.
I am paying for Mr. Roy, my lord.
Well, very, my lord, the innocent prayer.
Mr. Purkhaisto,
My lord.
they have not filed an affidavit here.
My lord,
But I have an instruction, my lord.
That instruction which has been given,
Yes, my lord.
you give a copy to Mr.
In para 6, my lord, it says, my lord, the amount has been credited to his brother's account, my lord. Not his account also, my lord.
I'm not disputing that.
No. They say that this these deposits have not been made from the unit fund.
Yes. And he admitted whatever amount has been credited, not his account, in his brother's account.
So, Mr. Purkhaisto,
My lord.
we will have to ask you to go before the civil court.
Let me obtain instruction for my, because I got the instruction today. Let it come on
Heard
27.
Mr. A. Purkhaisto, learned counsel for the petitioner. A.K. Purkhaisto, learned counsel for the petitioner. Also heard Mr. Also heard Mr. S. Thakur, learned counsel, representing Mr. S.S. Roy, CGC, appearing for the respondents, Also, the petitioner in the present proceedings has prayed for a direction upon the respondent authorities to release to him his contractual dues amounting to rupees 2,40,000. Also, it is projected by the petitioner in the writ petition that he had carried out works for the respondents, more particularly the respondent number 3, and the amount and the total bill amount was around rupees 9 lakhs, Mr. Purkhaisto. 6 lakhs. Huh? 5,40,000. Full stop. The petitioner further contends that an amount of rupees 3 lakh was released by the respondent authorities. However, in view of the fact that the petitioner at the relevant point of time did not have a bank account. You did not have a bank account. The said amount was deposited in the account of his brother, Sondon Boydo. Also, the balance amount of rupees 2,40,000 not being released, the petitioner has instituted the present proceeding. On the last date of listing, the Mr. S.S. Roy, learned counsel for the respondents, had placed on record a written instructions received by him in the matter, wherein the concerned authority had contended that there was no contract entered into with the petitioner by the respondents, more particularly the respondent number 3. Also, it was further projected that the contention of the petitioner of an amount of rupees 3 lakhs being transferred from the unit fund to the fund of his brother is perverse inasmuch as the account demonstrated by the petitioner in the writ petition is not the account from wherein the transactions are carried out by the unit concerned. Also, today, Mr. Thakur has furnished a copy of the said communication to Mr. A.K. Purkhaisto. Also, Mr. A.K. Purkhaisto submits that he be granted a week's time to receive instructions from his client with regard to the contentions raised by the respondents. Also, accordingly, registry to list this matter again on when, Mr. Professor?
28,
On 28,
8 of February.
28,
28. Let me see.
28 third no hobo na, fourth hobo. We can have it on 21st
21st, my lord.
Saturday.
21st, 22nd, 23rd, I will be out of station.
26,
26.
6 to 2026.
Look, only, may I have a look, my lord? Annexion 1. Annexion 1 specifically said contract was awarded to my lord petitioner. Annexion
You
1.
have your instructions in the
Sure.
light of this, Mr. Matter. See, this again is a problem. You find two handwritings there. You find two handwritings. The only problem is that we don't get Mr. Pukhaistam. Court is the last option for him. Huh.
Page 21 is the liability statement, Lordship.
Now, here that you have said, total liability is 2142 14649 169.
Lordship.
You have paid 65383.
Lordship.
This 65383 is against the work at serial number 5.
Lordship.
Hmm?
They made one liability statement, Lordship.
You have also, in your writ petition, how many works are involved?
Lordship, all 5 of them.
You have also done 5. So they have also put together 5. Your total claim is?
Total claim is, Lordship, now balance amount is 14,90,786, Lordship. That is the balance, Lordship.
That corresponds.
Lordship.
So we allow it.
Lordship.
But you'll get the order only on Tuesday. I'm not here. Tuesday, you will get the order. Monday, I'll sign it. Tuesday, you will get it.
Lordship.
Disposed of.
Lordship, 30 is also similar.
30 also similar. Just write down your names. You are Miss K.K. Chaudhary.
Lordship.
This is person.
Obliged, Lordship.
Yes.
I apologize for missing the matter on first call. Today, court number 1 was sitting in the old building, so I had the privilege of appearing there.
See, I think this is the first time.
First time I have appeared in that court.
That's a different place altogether. For us, that is a very hallowed place. Getting an opportunity to appear in court number 1, that one was something. It was a different feel altogether. Court number 1 is always a different feel.
My lord.
But that a place
Building.
had a different aura for itself.
We started there, my lord. Read petition was taken up by division bench at that time.
Means appearing there, I get no the feeling is something different. Yes. How long will it take?
Yeah, let's say, my lord, it will 15 minutes will be more.
Yes, why are you not?
There.
We are lordship gone through the circular, my lord. Actually, we are not aware of it. They are also not probably aware of it.
Circular, which one?
Page, my lord, 44.
44, Annexure 9.
Yes, my lord. Annexure 9, page 44. That is the main clutch of the matter, my lord. That it was issued on 5th of November 2014, my lord, by the MSME department.
Yes, what is your stand here?
That circular does not apply to this
Still not.
facts in hand. The issue is, your lordship,
He had
under
given
the
an
supply
industrial
code.
license. Industrial connection was given to you.
Yes, under the supply code, if you use your electricity connection for a purpose other than that for which it is supplied, that amounts to unauthorized use of electricity. Here they were having an industrial connection. They were using it for commercial purposes. That is in fact admitted in the petition also. They say that we are aware that using it for XYZ activities amounts to commercial use. The tariff which is fixed for commercial use and industrial use is different. For commercial use, it's higher. So, and since they have used it for a purpose other than that which is what it was supplied for, The amounts to unauthorized use of electricity, it has been assessed. There was an earlier and a previous round of litigation. There, this honorable court directed them to go before the appellate authority. Appellate authority as prima facie, yes, held that yes, you have used it for a different purpose. You say that you have applied for a industrial connection, so you are aware sorry, you have applied
What
for a
commercial connection not given to, they had applied for that also.
They had
Yes, sir.
dues to change yes, to change your category, you have to clear your outstanding dues. So they admit that also. Yes, there were some pending dues which had not been cleared.
But
And we have
another-
also taken a stand that we had not received any
Another
application.
point, my lord.
Huh?
We had not received that application. That is also discussed by the appellate authority.
Here, my lord, that the rented place, they are also having industry, my lord. Small industry.
So the industrial connection now, line,
Yes.
will also be billed as a commercial thing.
No, they had an industrial line. They were using it for commercial.
Okay,
Commercial,
now
yes.
the industry is not there.
Industry was there. All these are industry, my lord. Baking paper, glass paper plate.
There was a godown
printing
there.
Others. Devika Futuristic with the sales agency. They are still there, my lord. They are making paper books, commerce, trading and marketing. They are making.
What is your case, Madam
Coffee
Secretary?
bakery. Beg your pardon.
What is your case?
My case is, my lord, that we have applied for the commercial connection partly because we have got 82 kilowatt of my lord, connection, electricity connection, load of 82.41. And since that is of, my lord, very low, because then the go down night at night, my lord, no work happens. Because, my lord, in the daytime it's, my lord, open by 10 o'clock and go by 5 o'clock. So, my lord, no electricity. In spite of that, my lord, we applied for 2-3 applications for commercial line. But, my lord, at that time when we filed the case, appellate authority was not there. And, my lord, we approached this High Court. Because, my lord, they have not given, and, my lord, they have extra given, my lord, of 1 year penalty. 1 year penalty means we are paying our dues regularly.
Now, what did the appellate authority say finally?
Appellate authority said, my lord, that they have whatever we have paid for 4 months, except that he had, my lord, in his, my lord, last paragraph, my lord, page 67. The short advertisement of newspaper of money was and so. In view of the finding and observation made herein above, the appellate authority is of the opinion that it will be proper to prepare the assessment bill with effect from November 9/11/25 for the date of appellant's first application for a commercial connection to the SD Garbhanga ASD and full 12 months period to the due of inspection.
Then what happened? Did they do that? What is the error here, madam?
They have written a letter that they will be adjusting the
No, what is the error in this appellate authority's order?
order, my lord, in paragraph. I have said all the points, my lord. Paragraph. Let me see. Can we go through paragraph 20, my lord, that the impugn order and assessment is challenged on the following grounds. For that the
Page.
Page 15. Paragraph 20. For that the failure of the respondents to respond to the application dated so and so made by the petitioner for commercial connection is itself a deficiency of service and dereliction of duty. The respondents have not shown any cogent reasons as to why such application were not considered immediately. For that, before giving grant, my lord, we have applied for that. For that, the respondents have acted arbitrarily and with malafide by making unreasonable use of inspection report dated so and so. The said report was based on application by the petitioner for identification of load so that the commercial and industrial connection can be segregated and billed separately. The respondents, however, have made twist of tail by converting it into a report of malpractice based on which the impugn notice dated so and so has been issued. But the respondents tried to hide the fact.
Okay, ma'am. It's here, we'll see it. Yes.
Actually,
So these are the grounds.
the use of making this. Recently, my lord, in 2021, they have give us a bill of, because we are customer from 2000. And they have given a bill of rupees some 39 lakhs. Then, my lord, the directors approached the MD and chairman. It was rejected. Rejected, my lord, their bill was rejected. Well, every month they are paying. Why you are making all these bogus bills to harassing the people? Again, 24 they have revived. Again, I think MD is again stayed, my lord. That has been sorted out. So
We'll consider.
Yes,
Mr. Gogoi, why are you doing all this, Mr.?
paying bill regularly, and they are making such.
If I may take your lordship.
You always want to have a fight with your consumers, huh? Don't allow them to live peacefully. Huh?
Bill regularly,
Huh.
but it's not the.
Yes, what is your case?
My lords, if your lordship has the inspection report, first, that is from where the issue starts. It is at page number 31.
31.
Take your lordship to the. Lordship may come to the relevant portion at page number 33. This is a report dated 5/3/2016. I'm reading item point number 23. And above which equipments are found to connected top APDCL main at the time of our joint and physical inspection. The consumer running with HT industry but commercial category load found here. So and so to be taken accordingly as per terms and conditions supply of company.
So in lieu of the high tension line for industry, he was found to have been using it for commercial.
Commercial use.
Okay.
So then, your lordship, a notice of disconnection was issued to him at page number 36. This is dated 11/3/2016. This is under clause 5.8.3.2 of the supply code applicable then. Supply code. Then, your lordship, a provisional assessment has to be done in terms of section 126 of the Electricity Act. That was done. Your lordship will find that at page number 58.
38.
38. And the final assessment order, which was passed, your lordship will find at page number 40. If I may read that, your lordship, that will throw some light on the facts. This is to inform you, I'm reading from page number 40, your lordship, that on inspection dated 5/3/2016, use of electricity for commercial purpose from the existing service under industry category was detected. This is under quotes, used for any purpose other than that for which supply is contracted for is a malpractice defined under clause so and so of the terms and conditions regulations notified by ARC. As such, a provisional assessment bin amounting to so and so was served to you. In response, you submitted a fresh report of 750 kilowatt on 22/3/2016, removing the commercial load. I have gone through the facts and documents submitted by you.
Okay, then what happened? He approaches this court.
Yes, then he approaches this court challenging this order. So, in the meantime, your lordship, the division bench of this court had passed the order in the Chevalier judgment, where it held that since there is a statutory alternative remedy available, you have to first avail that. So, in terms of that order, this writ petition file was disposed of.
So 30% was deposited in 4 installments.
Yes.
And then they went up for appeal.
Yes, your lordship.
What is this? This is just the classification, page 44.
Page 40.
It's just classifying the various
yes, your
activities
lordship.
as manufacturing or commercial.
This is as per the MSME Act, not under the Electricity Act, or neither under the Industries Development Act. And if your lordship kindly has a note of this regulation, I'll just like to clarify one thing. This is issued by the director MSME. Here also, lordship will kindly have a look at point B. Activities considered as service.
That's what I said.
In fact, it is against them.
Manufacturing, activities, services.
So number
And
4
warehouse, go down, cold storage
is a service. Again, it's classified as a service.
Not an industry.
Not an industry. If they are relying on this, this is actually against them, your lordship. Though I say that this does not apply to the facts of the case. Then, your lordship, the order of the coordinate bench. The order of the coordinate bench in the first round, your lordship will find at page number 46.
What is the earlier order then?
Yes, that your lordship will find at page number 46.
The 41 order, what is this? Okay, okay. Oh, that was an IA.
Yes,
okay, fine. Yes.
The disposal order, your lordship will find at page number 46. And so the Operative portion, your lordship, is at page number
With
50.
regard to that Shiva alloy and the
Yes,
appellate
yes,
authority.
yes.
But nothing
Paragraph
here.
number 15.
It went before the appellate authority. Now the appellate authority has considered.
Yes, the appellate authority has considered. So I'll just read the relevant portions of the order of the appellate authority. Yes. It starts at page number 61, your lordship. I'll read from point F, yes. After going to the written replies of the respondents against the appeal filed by the appellant and the verbal arguments during hearings from both sides on so-and-so and so-and-so, it is clear that the case is related to unauthorized use of power due to change of category under section 126 of the Electricity Act 2003. The inspection team from the Technical Inspection Squad of APDCL inspected the premises of Messrs. So-and-so on 5/2016 in presence of the consumer representative. In the inspection report, the team recorded details of the electrical load found at the time. The team recorded some loads found in the premise under commercial category. The loads were used by such lessees/tenants for fabrication, industrial and storage purposes, which were nowhere related to the activities of Messrs. Eden Cold Storage Private Limited, as pointed out by the respondents. The assessing officer, namely the area manager IRCA 1, after going through the inspection report, initiated action as per the provisions of section 126 of the Electricity Act. Section 126 is reproduced below. Then at page number 163, I'll not trouble your lordship with the contents of 126. Page number 63, after going through the inspection report, because your lordship is after all exercising certiorari jurisdiction. So this is the application of mine by the authority. After going through the inspection report, the assessing officer, namely the area manager IRCA 1, came to the conclusion that the appellant had indulged in unauthorized use of electricity. So the area manager on 11/3/2016 issued a 24 hours disconnection notice to the appellant as per the provisions of clause 4.5.4 and clause 5.8.3.2 of the Electricity Supply Code. The appellant removed the extra non-industrial load within the notice time. So there was no disconnection of supply to the premises of the appellant. Provisional assessment bill amounting to rupees so-and-so was served to the consumer. The appellant filed an objection against the assessment order. After hearing, the assessing officer declared the provisional assessment bill as the final assessment bill on 16/6/2016. No procedural lapses were found on the part of the assessing officer are observed except the provision 4.5.4 of the Electricity Supply Code as mentioned in the disconnection notice to the appellant. The section is related to tempering, distress or damage of electrical plant, line and meter, and the appellant rightly protested it. Section 4.5.4 is reproduced herein below. I'll just not trouble your lordship with this.
It is not applicable.
It is not applicable. It is not applicable. Paragraph, page number 64. The appellant in the appeal raised the point that the respondent authorities failed to appreciate circular number so-and-so. This is a circular which the petitioners are relying on, issued by the Director MSME Policy Government of India, identifying warehouse and godown as service sector industries, including cold storage service. In this respect, the respondent clarified that some warehouse and godowns found during the inspection period were operating as separate establishments of commercial nature, and these activities were independent and no way related to the company's cold storage activities. Moreover, fabrication activities were also run by one of the tenants with 8 kilowatt connected load drawing from cold storage company.
Same from the petitioner company.
From the petitioner company. The activity was nowhere related to activities of Messrs. So-and-so. The respondent also mentioned that in the writ petition WPC number so-and-so, the appellant stated, your lordship will take a note of this, the extra unutilized area in the premises was leased out to parties, and the leasing out property is a commercial activity, and for such activity, electricity charges are levied at a commercial rate. I'll just take a pause here, your lordship. This statement, very curiously, is in the present petition also. I'll take your lordship to that portion. On oath, a statement has been made that they are aware that their activities amount to commercial use. The appellant also mentioned that he had submitted application to the SDE Gauhati Electrical Subdivision for a separate commercial connection on 9/11/2015 and 16/12/2016. But due to non-submission of revenue clearance certificate from the AM IRCA 1, which is mandatory as per section so-and-so, the SDA could not proceed for releasing a new commercial connection. The respondent also stated that as per Annexure 2 of the Supply Code for HT Industries connection, registration from the Industries Department of the state is mandatory. No such registration documents from the Industries Department was submitted by the appellant for the leased out fabrication and manufacturing companies working independently. Another point is that although the MSME registration in India started on October 2, 2006, when the MSME Development Act 2006 came into force, but the appellant had not submitted the Udyog Aadhaar registration till filing of this appeal. The appellant obtained first Udyog registration on 23/6/2021, long after inspection of the premises on 5/3/2016. Messrs. So-and-so became an MSME company having Udyog Aadhaar registration with date of Udyog registration 23/6/2021. The inspection is of 2016. As per the information provided by the respondents, the different national industry classification codes obtained by the company are as follows. So they have, yes. So this next portion is perhaps not very important, Your Lordship. They are discussing the memorandum of association of the company. Yes, 66.
Down below.
66, the second paragraph from the bottom, Your Lordship. The appellant informed that he had made several correspondences with the assessing officer, namely the area manager IRCA 1, intimating his initiation with the SDE Gorbhanga ESD to take a commercial connection at the premise to supply power to some upcoming commercial consumers on rent since 9/11/2015. However, he was not entertained as he had failed to submit the up-to-date revenue clearance certificate from the area manager, which is mandatory to release any new connection at the premise. The appellant stated that due to serious financial crisis, he had failed to clear the revenue dues on time. Then the appellant requested the area manager IRCA 1 to reconsider the provisional penalty bill on the ground that he had published newspaper advertisement for renting godown spaces on so-and-so and so-and-so and executed some lease agreements with some of the tenants in the months of February 2016 and March 2016. However, the area manager rejected the request of the appellant on fabrication of information as the stamp papers used for the agreements were purchased on 16/3/2016 and the agreements were executed on back day. So Lordship will take a note of that also. Again, the Transmission and Commissioning Team APDCL on 11/12/2015 in the inspection report of GR Dairy Food Products Private Limited, a consumer in the same campus with Messrs. So-and-so has mentioned the presence of a rubber unit in the appellant's premise. However, the appellant by letter dated so-and-so mentioned that the rubber unit had moved to their premise in the month of February 2016. Again, the appellant mentioned that after executing the agreement, the unit had moved to their premise in the month of March 2016. As the appellant had failed to produce valid, reliable document, it is difficult to ascertain the period of such unauthorized use of electricity. A copy of the advertisement in the newspaper for renting leasing of godown space, as provided by the appellant, cannot be firmly linked to Messrs. So-and-so due to insufficient information. In view of the findings and observations made herein above, the appellate authority is of the opinion that it will be proper to prepare the assessment bill. So in fact, my submission in this regard is that we should perhaps have challenged this order, because they have been given a concession without any materials to substantiate it. So if I may take your Lordship first to the statement made in the petition itself. Lordship will come to page number 8 at paragraph number 7. I beg your pardon, page number 6, paragraph number 4. The petitioner is aware that leasing out of property is a commercial activity, and for such activity, electricity charges are levied at a commercial rate. The commercial rate of tariff is 50% higher than the industrial rate of tariff. In anticipation of its requirement of commercial connection for leased properties, the petitioner submitted applications on so-and-so for commercial connection to the SDO Gorbhanga subdivision. Such applications were, however, kept pending in spite of repeated persuasion by employees of the petitioner. So, if I may, so they are aware . And otherwise, this paragraph is sworn from the record. So they are aware, and rightly so, that what they are doing is a commercial activity. It is not an industrial activity. So if I may take your Lordship to the relevant provisions of the supply code.
Just mark it for me.
Oh.
Just mark it for me.
Very well. Very well. I'll
just
very well.
mark it and give it.
Should I read out the relevant provisions?
Just mark it out and
very well. So then what, the other thing which will be relevant, your lordship, is the tariff code which was applicable.
Just to show that there are two different
tariffs.
just mark it.
Very well. So, and the difference between commercial category is tariffed at a rate of 7.55 for the energy charge, and the fixed charge is 115 kVA per month, and the industrial category is 6.25. This is per kilowatt, and the fixed charge is only 100. So over a period of time,
Give me a small note on that.
very well, very well. So
we got to examine whether the order by which you had prepared under 126, those decisions you have taken, whether that is within the purview of the law.
Yes.
Whether you had the power, whether there is anything else done. And secondly, whether the appellate authority had taken into consideration all required particulars to come
Yes.
to that conclusion.
Yes, your lordship.
If we come to that conclusion, then we need not proceed further.
Yes, your lordship.
We accept Madam's contention that the manner in which the appeal was considered is appellate order, this flow of the appellate order had not taken into consideration relevant documents. The MSME circular was there. That was not taken into consideration. Only noted, no conclusion drawn. So then we will have to interfere with that.
Very well.
Okay, madam. Anything more?
That it is applicable all over India, my lord, not only Assam or North.
So, yeah, do you have any judgments to support your case or these facts?
Then I think I should give by Monday, my lord.
Can give me
I'll give a
write-up.
written argument.
Okay.
But I'll also produce
annex those things to that.
Written argument.
Heard the Lana Council for the parties at some length. Hearing remains inconclusive. Registry to list this matter again on, you are giving on Monday. On Kundina Pari, Hopta all of Titus and Vistarika Bisek, 20.
20.
22. Will it be a problem?
22.
202.
Yes.
202. Good. Jigida order pass ko bola aapne.
Written submission দিলে তো ভালো হয় নহয় নে মই পিছে মানডে নাহো দেই মানডে নাহো মই টিউজডে দিম বা ইয়াতে দিব আৰু তাৰমানে